Hello, my name is Anam Khan and I'll be advising Ali. A number of tests have been created by the courts in order to reach some clarity in order to define an employee. Ali, to my knowledge, you are working for the Hatfield Paving Company Limited as a salesman, and in order to volunteer for redundancy, you need to prove that you're entitled to employee rights. The Employment Rights Act 1996, Section 230, subsection 1, defines an employee as being someone who has entered into or works under a contract of employment. Subsection 2 defines a contract of employment as meaning a contract of service or apprenticeship, whether express or implied, and whether oral or in writing. Ali, you need to demonstrate that you are working under a contract of service. This brings me on to the control test. The control test depicts the level of control exerted by the employer on the employee. Where a high level of control was detected, the individual was deemed to be an employee under the English law. Ali, you will need to provide some evidence that you are subject to a high level of control. The fact that you wear a uniform reflects your obedience in satisfying instructions which are given to you by HPC. You're given potential leads, to my knowledge. You are not left to your own devices in finding your own clientele. This could show how you are being instructed on how to work. The tribunal will consider the kind of relationship between you and HPC. By wearing the company's uniform, this is a strong indication of you conforming to their high level of control. On the other hand, HPC might argue that the fact that you wear their uniform is not enough to satisfy the control test. Many self-employed people wear uniforms for the company which they're offering their services to. In the case of Performing Rights Society Limited versus Mitchell and Booker Limited, it was the control test which was a deciding factor for the defendants who were being sued for breach of copyright of a jazz band. The judge concluded that a determining factor was the amount of freedom which is given to the employee by the employer. Ali, you can imply this by arguing that you was given a very limited amount of freedom. In the case of Ewens versus Noakes, it was held by Lord Justice Branwell that a servant is a person who is subject to the command of his master as to the manner in which he should do his work. The court may consider how involved HPC are in your work. You should argue that HPC instructs you on how to perform your tasks. Ali, you should be wary that HPC could argue that if you couldn't make appointments or visit potential leads, then you had the option of arranging cover for yourself. HPC could also argue in tribunal that they had not set you any specific hours. However, in retaliation to this, you could focus on the point that you were in fact directed to man the showroom once a month every Sunday. This brings me on to the integration test. The integration test involves being subject to disciplinary procedures, having employee rights and benefits, being entitled to holiday and sick pay. The determining factor in the integration test, as seen in the case of Stevenson, Jordan and Harrison versus MacDonald and Evans, which was judged by Lord Denning, he held that it is decided if somebody is an employee by if the person has become part and parcel of the company. You need to put forward the point that your work for the paving company is crucial and necessary. Work which is done for a business can either be integral or merely, as stated by Lord Denning, an accessory to it. You want to persuade the tribunal that you're not just an accessory to the company. The case of Belloff versus Prestra Limited concerned an individual who worked in a job which required some great skill. The courts in this case decided that despite her expertise, contracted position and her freedom to work for other companies, her work was done as an integral part of the organisation. Ali, you could argue your freedom to work for other companies has been restricted by HPC as you're unable to work for a competitor, which could be very favourable to your argument. The third test is the economic reality test. The economic reality test regards deciding if the worker is in business for himself. In this test, the courts must consider whether the person is in business if he can make any potential profit or loss. If the individual is able to profit from the work or suffer a loss from the work, then he can be seen as self-employed. Financial risk can indicate self-employment in the economic reality test. In the case of Market Investigations versus Minister of Social Security, it was held by Justice Cook that a factor which is deemed to be important in determining an employee is what degree of financial risk the person takes and what degree of responsibility for investment and management that person has. Ali, you could show the courts that you are not making any direct profit from the work you're providing. You haven't stated details about your wage, however, if you are on a set wage, this will benefit you in proving that you do not directly make any profit or loss. The fact that you make commission could be a point for HPC to argue. You need to prove that you don't suffer the financial risk. HPC could argue in tribunal that if you lose a lead, you will suffer reduced commission. Furthermore, you've been providing existing customers with presents out of your own personal funds, and you also pay your national insurance and tax contributions, which could work against you because you're using your own funds to fuel the company's business. If you have a wage, it will show that the company is providing your income. The fourth test is the multiple or composite test. The multiple test is slightly more flexible. The courts consider all the factors in your employment relationship. Justice McKenna decided that there are 3 requirements to go by when determining the employee's status in the case of Ready Mix Concrete versus Ministry of Pensions and National Insurance. The first one being that the employer agrees to provide work in return for new remuneration. The second one being that the employee agrees to control which the employer has on him or her. And the third one being that the employee that the other terms of the contract are consistent with it being one of service. Ali, you can satisfy that you provide work as a salesman to the Hatfield Paving Company in return for remuneration. You attend appointments with potential leads and create business for the company, and in return, HPC provides you with a wage and commission. In regards to your personal service being required, it's usually unfavourable in achieving employee status if the person is able to delegate their work to someone else. In the case of Express and Echo Publications versus Tanton, it was held that if the performance is limited, then the ability to provide substitute may still amount to a contract of service. You have the option of arranging cover for your work, and you usually let HPC know if you are unable to do this. It will benefit you to persuade the courts that your performance is limited and it doesn't require any special skill. The fifth test is the mutuality of obligation. The mutuality of obligation test depicts the relationship which exists between the employee and the employer. There must be a mutual obligation between the two parties to provide work and for the employee to provide services in return for remuneration. In the case of Nethermere Limited versus Gardiner, Lord Justice Dillon held that where there's a regular course of dealings between the employer and the individual in seeking employee status, a contract of service can be established. Ali, you can argue that you've been working for Hatfield Paving Company for nearly a year now, and this could be considered a regular course of dealing. You've been working for 11 months, to my knowledge, under a mutual obligation between yourself and HPC, and there have not been any instances where you've been denied your pay or have been unable to provide your services in return for remuneration, so it's fair to say that you have a strong chance of being successful as an employee. You conform to working under instruction, and HPC exert a high level of control over you. However, there are a few points in which you may struggle to bring your view across. For example, the fact you've been paying your own national insurance and tax contributions, and the fact that you provide presents for the customers out of your own personal funds. Taking all of this into account, the courts have a high level of discretion in making the final decision. Thank you.